4-prong test. So the hospital has to first of all look at, the nature of the information released. Well, in this instance, we're talking about an MRI. And let's say it was an MRI of a child who was suffering from a brain tumor. Okay? So clearly that's significant protected health information. Okay? Now, is there potential for that information to ruin somebody, either harm somebody's reputation or affect their finances? Well, if all the MRI report contains is the name of the child's date of birth, and the diagnosis as determined by the MRI, the likelihood is probably not. You can't stop there, okay? You have to also look at the recipient of the information. Well, we don't know who the recipient of the information is, do we? We don't know who lives at this other address, okay? So you have to go on. Whether the data, the entity then has to determine whether the data was actually seen or used. Well, in the example we just used, let's say that you have a very good-hearted, honest person, and they return the envelope to the hospital unopened. Well, the likelihood is the information wasn't seen, it wasn't used. Okay? So you can probably stop there if you get the envelope returned to you. But there has to be this analysis. And if you determine, as a result of going through this analysis, by, again, looking at the type of information, the recipient, whether it was seen or used, and there's a fourth prong, which I'll go into in my next example. If you can determine, based on your analysis, that the likelihood or the significant, there is no significant risk of harm to reputation or finances, then you don't have to report it. But if you can't do that, you must report it. You can't answer in such a way, each of these questions, that leads the entity to conclude that there is no significant risk of harm to finances or reputation. It has to be reported. And then OCR, the Office of Civil Rights of HHS, will make a determination as to whether you have to be fined or not. Now, another example. Let's say a patient at a hospital comes in for an HIV test. Okay? And the HIV test is positive, and the same thing happens. Okay? The results are mailed to the patients. It's an attempt to mail to the patient's address, but it ends up going to somebody else's address. That's very sensitive information. So you can answer by, you may be able to stop at question number 1 here, the type of information. Is there a significant risk that this information can affect somebody's reputation? Clearly, information getting out. Yes, ma'am.
Okay, so what if you using the address? You know how, like, when you live in apartments and stuff, sometimes the old resident, they'll still come to you.
Yes,
so what
ma'am.
if you using that address? How would that play a part in it?
Okay, so you don't know the address has changed. Is that what you're saying?
Right.
Okay.
Because I know the way. I don't like return or anything. I just know that that was just.
Well, okay, let's say the person does what you did. Let's say the HIV test result is mailed, not to you, but to somebody who has your philosophy about junk mail, and the test comes to that person and is thrown away. Okay, first of all, how is the hospital or the Office of Release of Health Information going to know that it's thrown away? They're not going to know that. Okay, so the answer to so first question is type of information. Clearly the information is very sensitive and certainly has a significant risk of harming someone's reputation. So, answer to question number 1 is yes, it can potentially harm somebody's reputation. The recipient of the information, we don't know who the recipient is. Now, if the recipient happens to be a business associate who is also now under the new HIPAA regs, are also governed by HIPAA laws, the likelihood is it's probably not going to be misused, and the likelihood is the information is probably not going to be used to harm the individual's reputation. But in the example you use, we don't know who the person is. We don't know what's thrown away. We don't know. In a situation like that, the entity has to report. Because if the mail goes out, it doesn't come back, and you never hear anything from anybody about what happened to this mail, that has to be reported. That has to be reported. And again, whether OCR is going to find that that was a violation, subject to a fine, is going to be up to OCR. It depends on what the individual who was mailing the information out was doing at the time. If the hospital conducts an investigation and determines that the person was on her or his cell phone talking to a buddy as opposed to paying attention to the work, the hospital may be sanctioned. If it was an honest mistake, or if the person simply moved without telling the hospital, the likelihood is it probably wouldn't be. But you know, in a situation like that, the hospital can't tell what happened to the information. There's no way to tell what happened. You just can't. There's no way. And so a situation like that's going to require that the report be filed. And again, it would be up to OCR to determine whether a fine would be imposed. Yes, ma'am.
I've got a question. One scenario is, I used to be a persuasion do this all the time, where, if there's a car accident or something like that, and you call the hospital up and say, how is so-and-so doing? They would tell you, oh, they're in stable condition, and it happens in the wrong time, I understand. And then also with people who, they call the hospital and say, can I have so-and-so's room? And they put you right through. How, I mean, seeing those two, I think back, I might say that's a violation, because they just told the person they're in the hospital. Or they just told their condition of the person's in the hospital. But, how specific is that information can you get without violating that?
Well, let me take your second example first. Now, when you're admitted to the hospital, I don't know if any of you received medical treatment recently at a hospital, but now you actually are asked whether you want people calling in to know that you're admitted. You're asked now whether you want the public, quote unquote, to know that you're in the hospital. So, and they did that, I think, as a result of HIPAA. But you're right, in the old days, you could call up and say, hey, Joe Green's a buddy of mine, how's he doing? And you can bring me up, or bring me to his room, and they bring you to the room. But they don't do that anymore. If the patient specifically indicates that they do not want anyone to know they're in the hospital, you're not going to know they're in the hospital. You're exempt. Now, what was your first example was?
Well, as a reporter, whenever there would be a car accident,
Right.
so-and-so was responsible, and the public wants to know, that they would call the hospital and say, okay, I'd like to know the condition of.
The hospital shouldn't be releasing that information.
They should-
Clearly, the hospital should not release that information. Now, whether they release it or not is an entirely different matter. But if Joe Green's involved in a car accident and almost bleeds to death, and let's say Joe Green is a very prominent person, and we all know that Joe Green was taken to General Hospital, and the reporter calls up and says, I'm calling to see how Mr. Joe Green is doing. The hospital is not supposed to answer that question. If they do, that's a violation of HIPAA. And it is clearly a violation of HIPAA. Unless Mr. Green has given permission, and I don't know why he would, or his family would, to release information about his condition. I don't know why he would do that. That's a violation of HIPAA. So that information shouldn't be released to or anyone else. Yes, ma'am.
At our hospital, the hospital now reported patients and families in a cold.
That's right.
That cold.
Right. A lot of hospitals do that. I know if USC does it. I don't know if Richland does it, but I know if USC does that. Which hospital? Timmy does it too. Okay. A lot of hospitals are going in that direction. So, but no, hospitals can't just willy-nilly release information about patients. They're not required to do that. Just a few more words about the changes. Most of the changes don't really affect the kind of work you're going to be doing. As I said, one of the most important changes has to do with penalties and now being presumed guilty as opposed to being presumed innocent. Another change that became effective this year is that business associates, we have a mini hospital on campus, at least I call it a mini hospital, our Student Healthcare Center. And our Student Healthcare Center enters into business associates agreements with a number of contractors. Those business associate agreements require the business associate, by the way, a business associate is nothing more than a person or an entity with whom a covered entity does business And as a result of doing business with that covered entity, forgiving that business associate, the business associate has access to protected health information. So the business associate agreement requires that the contractor, if you will, who's doing business with the covered entity, i.e. the business associate, not reveal HIPAA information, not reveal protected health information. Under the old rule, that's how it worked. Now, under the new rule, business associates themselves are, in fact, required by HIPAA to keep the information safeguarded to the same extent that a covered entity would be required. So let's say the hospital or the health center contracts with a laboratory to do to test bodily fluids, to do blood work and things of that sort. Under the old rule, we would have the health center would have to enter into a business associate agreement that says, hey, lab, don't reveal this protected health information, all right? And if the business associate didn't do it, well, they weren't subject to HIPAA, but we were. Now, under the new rule, the business associate is actually subject to HIPAA, and the business associate, let's say the business associate subcontracts on the lab work out to another smaller lab, they have to enter into a business associate agreement with that smaller lab. This is done because, as I understand it, most of the breaches in healthcare information took place took place after the information was revealed to a business associate. Because as I said, they weren't subject to it. Now they are, and they're subject to the $50,000 fine per violation. And by the way, that's a $1.5 million cap each year. So an institution who violates it would be fined up to $1.5 million a year. There's some other changes that have to do with patient access to information, patient requesting e-records and things of that sort, but I really don't think that's relevant. One thing that you may want to know, if you do or not, in the new reg, I think during the last time when I did this last time, somebody asked whether the records of decedents are covered by HIPAA. Who knows the answer to that question? Are dead people's records protected by HIPAA? They are? You don't think so? Okay. Well, they are. They are protected. And under the new rule, they're protected for 50 years. Why 50 years? I don't know. But under the new rule, they are protected for up to 50 years. So rest assured that if you kick off tomorrow, everybody's going to know why you died, what you died from for 50 years. Not that anybody cares. But at any rate, I tried to abbreviate this. I mean, HIPAA is a very legalese intense regulation, and I tried to simplify as much as I could. I really, as I said when I started, and I wasn't trying to be tongue-in-cheek, if you just mind your own business, protect your client's business, or your patient's business or information, keep your mouth shut, you won't get in trouble. I mean, really, that's really what HIPAA is telling you to do. Now, any other questions? I'd be more than happy to answer any questions you have. Yes, ma'am.
What was the fourth problem?
Okay, if a violation, that is, if a release or breach of information occurs, the institution is required to conduct a four-prong test. One, what type of information? By looking at, first of all, the type of information. Secondly, who is the recipient of the information? So, what kind of information was released? Who received it? Thirdly, what was the information actually used or seen? Type of information, who received it, was it used or seen? And fourth, to what extent were efforts undertaken to mitigate the damage as a result of the improper disclosure? So, what type of information was released? Who got it? Was it actually seen or used? And what efforts were taken, or what steps were taken to mitigate the potential misuse of the information? Okay? And as I said, depending upon the circumstances, you may be able to stop after usually going through one or two of those problems. But for instance, one involving the release of the HIV test, you don't know where it went. You can determine after the first prong that you got to report it. It has to be reported. So More questions? Yes, sir.
Would you mind briefly speaking to keeping the nature of our dialogue with your spouses, for instance, within the parameters of legislation?
Now, I wonder why you asked that question. Keeping the dialogue with your spouses within the parameters of HIPAA. Well, zip it up. Yeah. Although, technically you're not supposed to share information with your husband or wife about a patient or a client that falls within the category of protected health information. Technically you're not supposed to do that, but human nature being what it is, I'm sure spouses do talk about this kind of stuff. And, all I can say is make sure you know who you married. Make sure you know who you're married to. That's all I can say. That's all I can say about that. But technically, I think you know the answer. The answer you probably shouldn't be talking about it, but you're going to talk to your wife, you're going to talk to your husband about what happens at work. Yes, ma'am.
I'm sorry, just a little question. Whenever the regulators, because I'm sure within the course of the study, we're going to have like we did the process.
Yes, ma'am.
Can you use without getting specific information that we're experiment at first?
Right.
Information to talk about.
Well,
Not to give anything.
okay, let me read this to you, and then you tell me what answer your question. Individually identifiable health information is information including demographic data that relates to the individual's past, present, or future physical or mental health condition, the provision of health care to the individual, or past, present, or future payment for the provision of health care to the individual, and that identifies the individual or for which there is a reasonable basis to believe it can be used to do that. So, if you talk about the subject, quote unquote, an individual as a subject of an example, and there is absolutely no way to identify this individual, then it's okay to do it. But you can't say, I was working with a patient who's 25 years of age, he's from Inner South Carolina, has 3 kids and a wife, he's got a dog and a cat. If anything that you include in this scenario that would result in anyone being able to identify this individual is a no-no. So when you talk in generic terms in such a fashion that it would be impossible, very, very unlikely, locally unlikely, for the individual to be identified, I think you're okay. But the more information you use, the more likely it is that somebody may know this person. Because you may, go ahead, I'm sorry.
I said, well, I've actually been on the receiving end of somebody talking.
And you knew the person was? There you go. Because for instance, I might use an example of someone here. I might use an example of an individual. And I have no idea where all you all are from. And I may think, well, there's no way they can know what I'm talking about. Somebody in this room may know who I'm talking about. So you have to be very careful. There were 2 hands over here. Yes, ma'am.
So now everything has to be reported, but does reporting it mean that your agency will be fined and that does that automatically follow?
Your question was what?
If something is reported, does it automatically follow?
Oh,
that
does it
your
automatically
agency will
follow
be
that
fined?
it's going to be? No.
Okay.
OCR, the Office of Civil Rights of the Department of Health and Human Services will look at each case individually. But like I said, in the new regs, they actually say we're going to be much more rigorous about enforcing these regs because of so many breaches that have taken place. If you go through this 4-prong test and you can't determine that there is no significant risk of harm to a person's finances or reputation, it has to be reported. And once it's reported, then the Office of Civil Rights of the Department of Health and Human Services will make a determination about whether a fine is appropriate or not. If it's clearly a good faith, or mistakes are made in good faith, but if it's clearly an unintentional disclosure, that can be easily explained like for instance, the person is busy and transposes a 3 for a 1 in the address. You know, the likelihood is the institution probably won't be fined. But, you know, that's a decision which OCR would have to make. Yes, yes.
Yes, how do you keep your environment safe? I'm going to use a personal example. I work in psychiatric hospital, and sometimes I run into my patients on the outskirts of the hospital, and you know the patients with background, like let's say we have a patient who has an issue with molesting. How do you keep your environment safe without exposing patients?
How do you keep it, when you say you know?
Especially if you have young kids.
Okay, I'm not quite sure I understand your question. You encounter a patient on the outside, and you know this person has a propensity for child molestation, is that what you're saying?
I don't know. Child.
Unless they, and so your question is, and so what's your question?
If you have like family members, how do you kind of keep your environment safe without exposing it to patients? You know, like location for the they're around, but you know that they're not supposed to be in any vicinity of
Children?
children or people, women being killed.
Why is this person on the street? That's my
Right.
question.
That's why I guess that's why the program, because I see a lot of issues.
And you know, I guess it's just a matter of just trying to use common sense. If somebody approaches you and you've got small children with you, and the person has a propensity or has a history of molesting. Oh, I'm sorry. I was just saying, you know, maybe you want to just use common sense. I mean, if you know that somebody is a patient and has a propensity for certain acts, you know, I don't know. You just kind of have to use common sense and maybe just, hey, how you doing? I'm in a rush. I gotta go. I mean, but as I said, if he's that dangerous, he shouldn't be on the street. So, but my daughter is a clinical psychologist in New York, and she has patients who shouldn't be on the street. So I know that sometimes, you know, with the system being what it is, you can't lock everybody away. So I don't know that it's a question. I mean, just, I'm not sure I don't know how I handle that, to be quite honest with you. I mean, you can't say, oh, wait a minute, you're a child molester, stay away from me. You can't do that.
The law. So what if they were part of a registry list and had communities that had certain requirements of where they were allowed to not allowed to use, they were violating.
Well, now, what you've raised is a different issue. You
Yeah, I
know.
guess that information is important.
Right, that's right.
You could call and report that person, I just remember the public.
If you know that somebody's on the sex offender registry is doing something wrong, I mean, that's a different story. Yeah, that's a different story. Right.
So when you're with them, you can just say, be a little more non-conversational. I've got to get going and, you know,
Yeah, sex offender, information on the sex offender registry is not protected by HIPAA, okay? That's not protected by HIPAA. So, and it shouldn't be protected by HIPAA. I think there was a question over here earlier.
That's all right.
No, okay, all right. Yes, ma'am.
So I work in a clinic that deals with child sexual abuse, and so we get a lot of court orders for civil cases. And my question is just, if we're currently seeing the child for mental health treatment and they're under investigation by DSS if their allegations have not been proven yet, sometimes we'll get the alleged perpetrator's lawyer requesting information. And typically we follow that you're supposed to respond to the subpoena for information, but we don't necessarily have to provide it if it's going to invoke harm to that child. Is that pretty much always the rule?
So you get a subpoena for information about a child, okay? Under the subpoena rules in South Carolina, it's Rule 45, I believe, the South Carolina Civil Procedure. If a subpoena comes to you and you object to it, you have a right to ask the court for a protective order. And so that would be the appropriate response. If you get a subpoena for information you don't think should be disclosed, just say, you know, we don't agree with this, and then have whatever organization you work for as lawyer respond to it indicating we want the court court to rule on this. We don't think we should release this information. And I've had situations like that where the court will either not require that it be released or be released redacted or require certain restrictions be imposed on the recipient of the information. So that's probably the way that should be handled. Anybody else? Okay. I guess you're ready for your late morning coffee. Somebody said that. Any other questions? And I noticed the topic was legal and ethical consideration. So, I mean, if there are any other questions besides HIPAA-related issues, I'll be glad to try to answer them. Okay, the sexual harassment policy. I will confess not to be an expert on sexual harassment. That's supposed to be a joke. Bobby Gist with the Office of Equal Opportunities here at the University of South Carolina is the one who investigates sexual harassment or any other type of harassment. I will just tell you that obviously sexual harassment is not permitted. It goes without saying that it's a violation of university policies. But anyone who is, let me just say this about sexual harassment. Obviously, there is no law that says you can't fall in love with someone. Okay, we can't prescribe person's emotions. And we have situations right here on campus where students and faculty members have developed romantic relationships and have gotten married. Okay? But I would simply suggest that, again, we can't legislate emotions. We can't pass laws that say you can't fall in love with someone. But if you happen to be in a situation of a subordinate supervisor, subordinate situation, please, whatever you do, try not to encourage subordinates to become interested in you. And I don't know how else to say this. Just please try not to encourage that, because if the blank hits the fan, the subordinate is going to be presumed right, and the supervisor is going to be presumed in the wrong as having exerted undue pressure or coercion on this person to cause this person. And I know most sexual harassment situations involve males as the perpetrator and females as the victims, but it's not always that way. It's not always that way. So I would just ask you, or advise you to exercise some caution. Like I said, again, you can't legislate people's hearts, but try to use some common sense when you find yourself in those predicaments. Like I said, I'm aware personally of situations here at the University of South Carolina during the many years I've been here, where students and faculty members have actually fallen in love and gotten married to each other. So you can't prevent that. And just exercise some common sense. I would certainly try to encourage you, if you are in a situation of supervising someone, like I said, who's your subordinate and who's certainly younger than you are, that you try not to encourage that person to be interested in you. And you certainly don't let that person know that you may be interested in him or her, especially if the individual has made clear to you that he or she's not interested in you. Because the burden's going to be on you, the person who's accused, to prove that what the other person says is not true. And you don't want to cause problems for yourself or for the institution. So, anything else? Any other questions about anything in general? About who my favorite football team is, or the name of my cat? I mean, anything. Any other questions at all? Okay. Dan. Yes, sir.
Could you speak to mandatory reporting at all about, kind of what defines child abuse and kind of what would be a guideline there to follow?
What defines child abuse? Well, most children aren't born with fractured skulls. Well, actually, take that back. Some are. Depends on the nature, on how the birth took place. But normally, most toddlers don't walk around with fractured skulls. They don't walk around with broken bones. They don't walk around with welts on their back. So, I mean, again, what I said earlier about common sense, if you encounter a situation that raises in the level, raises in the mind of a reasonable person, or that would raise in the mind of a reasonable person, belief that this child has been a victim of abuse, you have an obligation to report it. You know, you just have an obligation to report it. And not just abuse, but neglect. If you are involved in if you work in an institution or a school, let's say, and a child is constantly coming to school wearing dirty clothes, okay, or is obviously not being bathed and properly fed, you need to report that. Has to be reported. Because that child is being neglected. It's obvious that child is being neglected. So, again, it's just a matter of common sense. There is nothing that says, you know, if A, then B, then C, then D, then report. You just have to use your common sense. But, you know, the standard is the reasonable person standard. The law has the reasonable person standard. If a reasonable person would believe this child is being abused and neglected, you would be unreasonable to not report that. So, any other questions? Yes,
I
ma'am.
have a simple question.
Yes.
While we're in field placement, would our field instructor or just our class instructor, or the university itself, would they be considered a business associate of our field placement?
Well, if you are in a field placement, and I don't know which agency you're going to be placed in.
Well, let me just give an example. So let's say I'm having an issue, not an issue, but I want to discuss a case or a client with an instructor because I think they may be able to give me some valuable input along with my field placement coordinator. Would USC, because they arranged for that placement with the agency, would they be considered a business associate?
All right, so if I understand your question, you have a question about what's the appropriate action to take with respect to a client. And you want to discuss that with your professor,
Right.
and with with somebody at the field placement agency itself?
Specifically, just USC, my instructor.
Okay. All right.
If it's an issue, I want to talk to them about.
You are being supervised by this instructor, I assume. Or
Not
this person
necessarily.
is this person your?
And it's going to be another class that I'm taking.
Well, so our students, when they are in field placement, do they have a professor assigned to them?
They have a field instructor, and then you have a field liaison. And we're going to go over the protocol for that, but you would have a specific chain of command that you would go through with the issues that you felt were problematic or ethical in field. And we're going to get to that level of resolution later. But that's why there's no, the thing is when it comes to ethical and legal stuff, there's no absolute. This is why I talk to Cliff all the time, because it depends on the context and the situation. You all know when something doesn't feel right, but I think that's a really good question. Who all can you talk to? And the thing is, there's a proper protocol to follow. If you feel that there's an issue, you first should do a field instructor. Next would be a liaison, which is an employee of USC that's responsible for monitoring the integrity of the practicum experience.
So the reason I asked the question about whether you have someone assigned to you or not is that I think it would be appropriate to talk to the person assigned to you, but you wouldn't be within your right to just talk to any professor within the college social work, because that person really doesn't have any need to know the information about a client that you have concerns about. So, anybody else? Okay, go Gamecocks.
We're going to follow. Mike had a different take on what you might be asking too, and that is if you're in class, and I think it's similar to the question this lady up front asked, if you're in class and they're wanting to discuss something around group techniques, you can talk about general things that are happening in field, but if it rises to a different level and you say that, you can't say names. You always have to safeguard and protect that information. And professors understand that and are aware of that. So they're not going to ask you to disclose things in terms of assignments or projects. That would be a violation of HIPAA because they also have to worry about firm voting. They understand that. But if you're talking about you find yourself in a situation and you want to use a professor's consultation, there's a different protocol for that. We're going to talk about that more later. Thank you. Let's give Cliff a big round of applause. Thank you so much. Okay, I think what we're going to do is we're going to go ahead and let you take your 15-minute break. respectful of that, so we can keep, because we've got a couple things we've actually moved to the end of the day. We're a little bit behind. So 15 minutes, and I'll see you back in 15.
I have a daughter that lives here. So I stayed with her last night. So I come up home. Right. Oh my
I was gonna say, because she'd always said to me, oh, I always wanted to that girl. And I was like, what is it? Right, lights, and it's of your son's blood. Well, and that's what I said, there's a, I know there's a little
I was walking across the street. I was like, oh, look what I'm doing.
Hi, Ashley. How are you?